Mr. Jarman.
I'm grateful, my lady, and particularly grateful for being referred to the F2 test claims case in the Supreme Court. I note there that their lordships referred to a spectrum. I will not be surprised, I submit, that I'm either at the lowest end of the spectrum or the highest end of the spectrum, depending on which it is that most easily lends itself to allowing the point to be argued. But what is clear is that there are factors there which I say do lend themselves in favour of allowing this point to be made. The first is, I submit, that actually when one analyses the transcript, and the way it's put in my defence skeleton argument, he calls it an implied admission or concession. I submit it's highly confused. I will very shortly take you through passages, but there is no clear and unequivocal concession of anything.
Sorry, are we talking about ground one?
Well, this is again, I'd say in relation to round one, yes. It's all very confused.
Yes, but you're saying concessioning in relation to ground one. I haven't analysed ground one as a concession. The question is whether you should be allowed to argue something that was not argued at all.
Sorry, my lady. Yes, forgive me. I accept that it wasn't argued at all. Of course I do. I'm simply submitting that there is perhaps a distinction between not arguing something and conceding something. It may be a moot point, but I submit that if you read the transcript, to say we didn't argue something is fair. To say we conceded something is a little bit more argument. Well, it's put as an implied concession. So that's the first point I take. The second point I take is it is one of pure point of law. The third is that there was argument heard on most of these issues. If one looks at my learned friend's submissions and indeed his skeleton argument, most of the cases I'm citing to you, he cited to the trial judge. So,
well, no. Yes and no. There was. It seems from looking at the transcript that there was argument about, Gretchen Barkham, etc., Davis, all the rest of it. But I don't think there was anything that comes in on the transcript which suggests that it was argued on a Creasy and Soul basis, that in fact nobody had a right to occupation.
I agree with that, my lady. The only reason I have a caveat on that is, and it is very confused, and maybe it's just me, but there is a passage certainly where the learned judge specifically asked the parties whether there's any authority on the question of trespass.
Okay. Where is that?
I think this is 428.
Where at 428?
Sorry, page 428, starting a day.
Yes.
I understand Mr. Kember, my predecessor, to be saying, well, it should all be paid to the estate, which I agree is closely analogous to what the position in Creasy and Soul would be, but not argued. But then goes over the page to 429. Mr. Kember says that he refers to the bottom of the page 428. Mr. Sharples has said that there is no authority he's aware of in respect to the proposition that the full amount is payable to the estate of Mrs. Bibi. I do not advance an authority for that proposition. So although that is my pleaded case, and I accept your ladyship's argument whether that is, your lordships will have little difficulty in dealing with that.
I'm sorry, I can't find that on page 429. Am I on the wrong place?
118 and 119.
Oh, I'm so sorry.
428, 429.
Thank you.
It's the two sets of pagination.
But this is a different point again, isn't it? This is about, it is a point about whether it belongs to the estate, but it's an issue about whether 100% has been claimed or whether 25% has been claimed. This isn't going to the question of whether one is a trespasser at all.
My lady, I accept that. All I'm simply submitting is there is a spectrum, a clear concession. If one looks at the Supreme Court case, there's a very clear concession in what was no doubt a highly pleaded and highly complex piece of litigation. Here, the way it's put against us is an implied concession, I say, a failure to argue that the whole thing is confused. Creasy and Soul was not cited. I take you to that passage to say, well, if ever there was a moment to say, well, actually, your lordship, here's the case you really need to look at, it was there, and that wasn't cited. Argument is heard on the totality of the arguments being put forward. So there's no suggestion that, as it were, the trial would have been conducted in a different way. And then, in relation to the judgment, if I have understood the judgment correctly, the learned trial judge...
Well, you say it wouldn't have been argued in a different way, but if you were arguing nobody has a right of occupation, none of the things, well, very few of the things which were argued would have been argued at all. And you would surely have then focused on whether or not this was a case of trespass, or whether there was any licence, and there would have been different evidence.
Well, my lady, that takes us... I'm afraid they're interlinked, because that takes us back to the question of the consent order and what it meant. Okay. And I submit, rightly or wrongly, we came to the trial in the understanding that the question was how much. And I accept, my lords, my lord, my ladies, that how much could be zero. But the question was how much. So the principle was not of whether it was an occupation when it was payable was not engaged. And so I say, for the purposes of exercising your discretion under the F2 case, it is relevant to look at that. How much relevance you give it is, how much weight is, of course, going to be a matter for this court, but it must be relevant. What I also say, though, is that I don't think the judge was taken in by any concession. He doesn't seem to deal with it in that way. He seems to flag up the fact that there was a request by my learned friend to withdraw a concession. He deals with the point about solicitor's authority. He effectively deals with it in the way that my Lady Anders has dealt with it, is that to say, well, actually, I don't construe it in that way, because if any. So if that was a concession, it wasn't one the judge bought into. He didn't stop his judgment and say, well, I don't need to deal with that because Mr. Kemmler's accepted it. To the contrary, he says, well, actually, what I don't find is that agreement requires me to impose it. And then he goes on and says, therefore, it's in my discretion. And that's the argument we've had earlier in the day.
But it doesn't deal with trespass, and the transcript does not refer to no one having a right of occupation, quite the reverse, except there are those references to percentages to which you referred us.
Yes, my lady. I'm trying to put it as fairly as I can.
Yep.
But as I say, I think a failure to argue the point amid what I would contend is mass confusion would be a better way to describe it. And that is relevant because it doesn't affect the way the trial is going, because all those points were going to be argued, because unless you had Creasy and Soul before the judge, even if we had argued that point, the judge might not have accepted it, he might not have bought into it. So you would still be arguing the French and Barsham versus Davis point. That's the first point. The second point is it doesn't affect the evidence. And nor can there be any detrimental reliance. And obviously, on from that, I don't have to show exceptional circumstances. It's a question of spectrum. I say that spectrum is one which leads to that outcome. And as I say, the real fault is that Creasy and Soul wasn't cited.
Yes.
My lady, my lord, unless I can assist.
For my part, thank you. Thank you very much.
Subject to reply. I'm grateful.
Mr. Sharples.
Dealing with the FII point first, I take, unsurprisingly, a different view on it to my friend. I'm also grateful for the guidance of the court over lunch. What it says at paragraph 91 is that relevant factors include whether or not first of all, in paragraph 90, forgive me, the spectrum that my learned friend refers to is, on the one hand, if there has been a full trial with evidence, and that the new point either might have changed the course of the evidence or required further factual inquiries. That is the spectrum, the end of the spectrum where one does not grant permission. The other end is where it is a pure question of law in relation to which all relevant facts and all relevant inquiries have been conducted. This is the first of those. At paragraph 93 also, the court said this. The appeal court would normally, I've scratched down my note of what it said. The appeal court will normally strenuously avoid a result, an outcome which results in the parties who have already gone to trial having to amend and deduce further evidence and to apply the law to those new facts. The need for a retrial is normally a strong and determinative pointer against allowing the point to be taken. And at paragraph 91 and 92, the court also referred to the following factors. The stage at which the point is taken, here it is taken on appeal, very late. Secondly, whether it involved the abandonment of the claim, as it did here. And in fact, it involves the entire recasting of a claim from one of occupation rent and an equitable account as between beneficiaries by virtue of ouster or something similar to one based purely in trespass. Thirdly, would it require the parties to amend their pleadings? Well, yes, it would require them to effectively start from scratch. And then would it require a further trial? And in this case, we would say also that is so, because the nature of the liability is different. On the one hand, it is trespass, it is present without either a legal right or the consent of the legal owner, and therefore one would have to look at the nature of the beneficiary's rights of occupation here, and also whether or not, irrespective of that, the legal owner in whom the estate is the property is vested is Mr. Ramzan or Mr. Ramzan's estate, and did he give consent to effectively his own occupation and that of his family? Now, by doing so, it may mean that his estate is subject to a different liability, a liability for breach of trust, but that is yet a further point. The point for present purposes is that the nature of the liability is an entirely different one. The claimant would be different. I think for an occupation rent claim, it's the applicant. For a trespass claim, it would be Mr. Ramzan's estate, or rather, or at very least, he would.
Wouldn't it be Mrs. Bibi's estate?
Well, of course,
if you unscramble all of the previous transactions, yes. I think it's probably Mum's estate rather than.
Technically, the legal ownership remains in Mr. Ramzan's estate, but I accept that he must hold it on trust for Mrs. Bibi's estate. So at the moment, yes, that is correct. But ultimately, it would be the first respondent and not the applicant. Thirdly, the defences are different. As I say, consent of the legal owner as distinct from equitable defences. The limitation period is different. 6 years as distinct from none, but subject to equitable defences like late cheese. The amount is potentially different and the matter of calculation, because then one gets into questions of, is it the detriment to the claimant or is it the benefit to the occupant? And in circumstances, they may be prima facie measured by the letting value of the land, but are not necessarily so. Whereas in an occupation rent claim, as we know from Stack and Dowden, as Lord Newberg has said, there are alternative ways of calculating that amount. It may be the amount by which the non-occupying beneficiary is out of pocket, not the benefit to the occupying beneficiary. And then finally, there are set-offs. In relation to occupation rent, I have the potential set-offs of the mortgage, certain parts of the insurance and the improvements which I did to the property, unless I can get within I think I could possibly get within an unjust enrichment claim in relation to the mortgage, but not, at least without a great deal more, in relation to the improvements to the property, and so forth. And so one can see that one is not a mirror of the other. In fact, they are nothing like each other.
And you say not only are they nothing like each other, you're saying there would have been a different evidence, or
Yes.
you'd have sought different findings.
Yes, immediately I can think of, there are limitation issues, there are consent issues and so forth. There may be an acquiescence issue, for example, as to whether or not implied license was granted by virtue of delay, but that is off the top of my head, to use the vernacular. But finally, I think on FII, there are a number of factors which I wrote down so far as they apply to this case, so what I say now is not verbatim, but I rely on. And that is that the claimant, the defendants have already committed very substantial resources to this litigation. They have had to, they instruct me, take out loans even to pay for my attendance today. Mrs. Ramzan at least, committed to buy the property on the basis that the only liability that they say they thought they were buying out the occupation rent claim, but of course they weren't. But nevertheless, objectively viewed, they were buying it, overpaying for it on the basis that they were facing potentially an occupation rent claim, but not a trespass claim. They would have to then face effectively a retrial. We would start as of from the day, pleadings, new evidence, and a further trial on what would be a trespass claim, not an occupation rent claim. And so in my respectful submission, for all those reasons, it's not appropriate to permit the applicant to withdraw, to raise these new points. My learned friend has argued that this isn't simply, this isn't a case of concession as it was in FII. With respect to my learned friend, I disagree with that. In fact, if we read the transcript of the submissions, first of all, it is clear, as my lady has said, that this case was fought on the basis that the parties both had occupation rights, and it was the denial or constructive denial of one's occupation rights which triggered the entitlement to apply for an occupation rent. And secondly, and my learned friend below argued that, and we see that I have the numbering from the bundle rather than the transcript itself, 44728 is where he argued exclusion, and then 453 he said in terms, your lordship has to consider in my submission the two purposes for which this property was held: to realise the force of his interest, and that's Mr. Ali's interest in the property, balanced against housing Mr. Ramzan and Shanaz Ramzan until that point, but there was a clear expectation that the property was to be sold. So it is clear in my respect position that there was, if not in terms, then in substance and in a concession that the second respondent had an occupation right. The second point is this: it is not so obvious that, as my learned friend has implied, that they do not, by virtue of that Mr. Ramzan's estate does not. My learned friend relied on Bernardo's case for the proposition that a residuary beneficiary doesn't have an interest in the residuary estate. That isn't the proposition for which Bernardo's is authority, not quite the proposition. It is that until the residuary estate is realised,
Yes.
there is no such interest. But the converse of that is, of course, that once it is realised, once it's clear that these assets are not required to discharge the estate's debts or for the to raise administration expenses, they are assets to which the residuary beneficiary can claim an interest, in which can claim an interest. And it follows then from that, and in particular section 18 of Talata's application of section 12 to cases of personal representatives, that if a residuary beneficiary can bring himself within section 12, he may have, or he has, a right of occupation. The words that are important and which encapsulate the Bernardo's point is that it is a beneficiary who is a beneficially entitled to an interest in possession in land. Unless and until the residuary estate is realised, he does not have an interest in possession in land, but once it is, he does. And therefore, as long as he satisfies A or B, that is the purpose of the trust, include making the land available for him, or the land is so held so as to be available for him, he potentially has section 12 occupation rights in relation to that, notwithstanding it is part of the, or had been at one point part of the residuary estate. So one then says, well, what about Creasy and Soule? And like my learned friend, I struggle with the complexity of the case, and I think I disagree with him in this respect on it, and respectfully so. In Creasy and Soule, of course, there was mother and father's estate, each of which owned certain shares in certain parcels of land, different shares held on different trusts. The result of them, and Michael, the defendant, succeeded to certain shares in both his parents' interests. I think his interest under his father's will was subject to a life interest in favour of the mother. The nub of the basis of the decision, and I think it's paragraph 129, is this: that Michael's interests were those under there was a main trust under which the property was held after the mother's death. That is, partly it was held by the trustees of the land on trust for mother's estate and for father's estate, and then each of there were sub-trusts under each of those for the beneficiaries under the respective wills. The learned judge decided then that such an interest in land, was not an interest for Section 12 purposes. It must be an interest in land. And for that reason, therefore, Michael could not bring himself, as it were, to the gate in terms of Section 12.
It was one removed too far.
Yes, yes. And then he contemplated, I think, in paragraph 129, what would be the situation if the main trust disappeared and the trustees reconstituted themselves as trustees for the beneficiaries. And he speculated that it was possible in those circumstances that Michael could have an interest, a Section 12 occupation right. So there is nothing in Creasy and Soule which, in my respect, submission supports the proposition for which the applicant relies on, the appellant relies on, which is that a residuary beneficiary by definition cannot have such rights. What we have is in the specific, a decision that in those specific facts, Michael did not have those rights. But that tells us nothing here, in my respect, submission.
And indeed, you might say it's a fairly startling proposition that you wouldn't have. Let's take the standard situation of the family home being split between siblings, and it's a direct estate, without all the complexities that you have in Creasy. So there's an equal share. Obviously, it can't be realised until such time as probate or administration is completed. Right. You say that the operation of Section 18 and Section 12 is such that you would have a right of occupation.
Yes, potentially so.
Yes.
So subject to qualification under A or B, subject to the estate being sufficiently flush that they wouldn't be required
to sell it to meet other.
Yes, indeed so. Yes. And those would be matters. One of the matters to which the court would have to decide if this matter were remitted for the determination of this point of law.
Yes.
Before one even got to the question of trespass.
Sorry, before it even got to...
The question of trespass, forgive me, I gabbled.
Yeah.
My learned friend has argued that one looks to the will and only the will in those circumstances for the rights of the parties. In my submission, there's no basis for that. The analysis is, as I have said, do you qualify under Bernardo's? And if you do qualify under Bernardo's, do you qualify under Section 12? It need not, therefore, be expressed within the will itself. And indeed, if that were so, in virtually no cases of, for example, cohabitee co-ownership cases, would there be occupation rights for the same reason that if one looks at the trust, it is simply held for A or B in equal shares or such shares as are determined, but says nothing about the rights of occupation. It's all implicit, of course, that it is for the joint occupation of usually the two legal owners. But if my learned friend is right that one is confined purely to the question of the trust itself as written in order to determine those occupation rights, then that would be a startling result and cannot be, in my respect, submission correct. It follows that there's a further possibility, I hesitate to raise this, which is this, that because of Section 12, my client has occupation rights, but likewise because of Section 12, Mr. Ali doesn't, the applicant does not, or the appellant does not. That may be because of, and that may be for two reasons. It may be because he fails to satisfy, well, it'll be because he satisfies section 12, but he may fail to do so for one of two reasons. First of all, because it was never the party's intention, irrespective of my occupation, that he have a right of occupation, in which case, whether I am there or not, he fails to satisfy section 12. And secondly, the point, it may be that by virtue of my occupation, therefore he does not satisfy section 12. I accept that in the latter case, the fact that he does not have occupation rights because I am there does not prohibit him from claiming an occupation rent. But if he does not have occupation rights independently of my occupation, then one queries on what basis it would be fair, if I do have rights, for the occupying beneficiary to pay the beneficiary without an occupation right, an occupation rent for his occupation. In a sense, what one is doing is upsetting the trust and saying, for example, let's take, if one were to say there were a trust that said to A and B in equal shares, but on trust for A's occupation for life. It would be open in those circumstances, if my learned friend is right, for B to say, well, that's all very well, but I'll have an occupation rent from you, because I have no right of occupation. And in particular, if one then applies French and Barcham and says, because I have no enjoyment of the land, because it's not reasonable for me to occupy, indeed I cannot, therefore the starting point is that I'm entitled to an occupation rent. It means that in all those circumstances, unless there is something exceptional, a beneficiary with an express right of occupation would always have to pay an occupation rent to a beneficiary who has no right of occupation.
Well, it also makes a nonsense of it, because it would mean that the person who had no occupation rights would be better off financially than a person who did.
Indeed, yes. That was my next point, in fact. The argument, I suppose, against that would be simply to say, well, it's up to you. The difference is that you had chosen not to exercise your occupation rights, but that may be an argument, but in my respect...
I'm sorry, I'm missing something. Why would they be better off?
They would be better off because they could say, I always satisfy the French and Barcham test, or whatever test it is. I cannot occupy the land, or it would be unreasonable to expect me to occupy the land, because I cannot.
But what I don't understand is why that makes one better off than the other.
Well,
one has the benefit of occupation, but he's paying a rent to the other who doesn't.
Yeah, no, my lord. It is not that they are better off than the occupying beneficiary. It is that they are better off than another beneficiary who is not in occupation but had occupation rights, but chooses not to exercise them for whatever reason. In fact, it's not just that he's better off, as I say, it means that he's almost automatically, if my learned friend is right, entitled to an occupation rent, which cannot, in my research solution, be correct. I think those were the points that I was going to make in relation to ground one, and I think I rather got ahead of myself, having argued the point of principle as to whether or not it was open to my learned friend to argue that. What I've said as a matter of principle in relation to whether it is open to my learned friend, I also apply to ground two as well, and I won't repeat those points. In response to my learned friend, as I think the point has already been taken, it is true that the learned judge did not, in terms, deal with my application to withdraw the admission if I needed to, but that is because he found, as a matter of interpretation, that the 2020 order was implicitly qualified by the words, if any, as was the memorandum of agreement which it implemented. There is no appeal against that finding. The one oddity is that I think there's a slip of the tongue. The learned judge referred to it as the 2014 order, where it's clear he's talking about a recital which the 2014 order never contained. He must be referring to the 2020 consent order in those circumstances. And so, in my submission, even if it were open to my learned friend to argue that point, it doesn't get off the ground because it doesn't answer the real point, which is the learned judge has construed it in a way that means it isn't a contractual estoppel or a contractual bar on me disputing my liability. If it were, there would be further arguments I would raise in relation to that, and I set them out in my skeleton, and I won't repeat them, such as consideration, mistake rectification, and so forth. Given the point is that the concession, or the apparent concession in the wording of the recital, goes beyond the agreement set out in the memorandum of agreement in relation to the purchase of the property, or the appellant's share. My final point on that would be, in any event, I query whether or not a contractual estoppel or bar of that nature could bar the court from exercising its broad judgmental discretion. For example, if it thought that it was inappropriate to grant an award of occupation rent, notwithstanding an apparent concession, then in my submission it would be a difficult decision to say that it was bound to do so. Or indeed, one can ask the question, and bound to grant how much as a bare minimum? Could it have set it at £1? If not at £1, if something, then what? What was it barred, or what was it being forced to do by the recital as my learned friend construes it? And so for all those reasons, in my submission, that is not open to my learned friend either. I then moved on to ground 3, the exclusion point. There are a number of those points were not on which my learned friend relies: the invalid will, the will dispute, the failure to sell, and not the parties' relationship, but those points I don't think were raised below. There is an important, I think, stepping back, an important point to consider here, that there is in fact a two-stage test for an occupation rent.
Before you go on, those points that you say were not raised below, if you could just repeat them for me.
Forgive me. Yes, that the second defendant had been relying on the invalid 2003 will. Secondly, that there was a dispute in relation to that will. And thirdly, that, well, I think actually that was raised. I was going to say, thirdly, the failure to sell prevented the applicant from realising his interest in the will. I think that was alluded to, in fact.
Right.
In fact, so I think, my lady, it's just the first two of those that are new points. The point I was going to say is that, stepping back, there is actually a two-stage analysis, although it is sometimes now hidden in any claim for an occupational rent. The first is, does the court have jurisdiction to make an award? And secondly, should it? Now, in cases where ouster or something similar to ouster was required, the nature of that two-stage test was obvious, because the threshold test was a question of fact. However one defined it, whether it was ouster, physical ouster, whether it was constructive ouster, whether it was simply unreasonableness in the French embarkment test, it mattered not. The point is, there is a threshold test. Then the second issue is whether or not one should exercise it. If one accepts the more recent formulations, would it be unjust, or is it just to order the occupying beneficiary to pay such a rent? That appears to conflate those two stages, but they are conceptually distinct. If one, for example, if one applies French and Bartram and asks baldly the question, in ignoring the Davis qualification, would it be unreasonable for the beneficiary to occupy, the non-occupying beneficiary to occupy? If that is the threshold test, then that is not the only issue, which if the answer is yes, the court must take into account when it considers whether or not to award that a rent, plainly so. And it follows from that, if that is right, that to say, as French does, that if it would be unreasonable, therefore one inevitably, if not invariably, or whatever the phraseology is, orders an occupational rent, must be wrong. Because it is jumping over the second stage, or thinking that the second stage text analysis is necessarily answered by the first stage. And so then dealing with the merits, the learned judge did not say that an ouster was necessary. In fact, he looked at the matter in the round. He had French, Davis, and so forth addressed to him, and he asked himself, would it be unjust in the circumstances, the widest definition of the threshold test, would it be unjust in the circumstances to not to order an occupation rent? So in my respect submission of the first stage of the analysis, there is no relevant direction shown. He certainly did not say, as I say, that ouster was necessary, having been referred to Pavlo, Murphy and Davis. He pointed out, I think, that indeed, quoted the words from Davis, that the court's function of the court is to do broad justice in the circumstances.
Well, Davis is very much along the same lines as Pavlo. It's French that's the slight outlier.
Yes.
And it is, I think, with respect, a little difficult to reconcile the jurisprudential basis articulated by Mr. Justice Blackburn with the approach of Mr. Justice Snowden. But Mr. Justice Snowden's articulation seems to me to be much more in line with everybody else's, going right way back to Lord Denning.
Yes. And if I may say so, the reason it appears to me is that Lord Justice Blackburn's analysis decouples the question of unreasonableness to occupy from any consideration of the occupation, the nature of the occupation, or the benefit, or the relationship of the parties, and so forth. And so, if that's right, if one decouples that, one then gets into questions of, would it be unreasonable to occupy because of my lifestyle, because I live elsewhere in the country, because of my social standing, and so forth, which cannot possibly be right. The Lord Justice Snowden's, as he was then, Mr. Justice Snowden's approach, as he was then, reattaches, as it were, the question of unreasonableness with the relationship between the two beneficiaries, which is of the essence of the earlier cases, whether it be actual ouster or constructive ouster. In fact, it's also consistent, I would respectfully submit, with the trustee and bankruptcy cases. They are merely applications of the broad principle, which is it realistic to expect the trustee in bankruptcy to occupy, not full stop, but to occupy whilst the other beneficiary is in occupation of the property? That is the question which the courts have asked themselves in those circumstances. It is the oddity, the outlier again, is French, which at one point seems to imply that the trustee in bankruptcy has no rights of occupation. If one reads on in other parts of it, and I can take my lady to the relevant passages, he accepts that that is so, albeit that he may, at least in theory, have such occupation rights, but by virtue of the other beneficiary's presence, applying the Section 12 criteria, he would not. Now, obviously, if the only reason one does not have Section 12 rights is because the other beneficiary is in occupation, the other beneficiary can't use that to argue against an occupation right. But if you don't have an occupation right, irrespective of the occupying beneficiary's occupation, and therefore Section 12, in my respect, it's very difficult to define or discern a principle on which the court can decide whether or not to award an occupation rent. To repeat what I said earlier, by definition it is upsetting the balance of the parties' rights under the trust.
Well, you go right back to basic principles, which the basic principle is if two people own the property jointly and one of them is in entire occupation of the property, it doesn't follow that he has to pay the other person an occupation rent.
Indeed. And Mr. Justice Snowden, as he then was, makes, I think, that point, and that is the point I think he was making it in Davis, which is saying that it reverses, French and Barcham reverses the starting point. And in fact, it's worse. Melania Friend says it reverses the starting point in relation, French and Barcham potentially reverses the starting point, if he's right, in relation to trustees in bankruptcy. Well, if Melania Friend is right, the starting point is reversed for every beneficiary who is not in occupation.
Yes. It's an extension of French and Bartram.
Yes. So far as the specific points on which, then, aside from that, apart from the specific, dealing with a couple of the specific points, Millennium Friendly relies on us saying it is unreasonable to require him to occupy. The first was the invalid will. That, however, is a limited period when this argument, if it is good, applies. I think the grant of probate was taken out only in 2010, late 2010, and then the property was transferred by the two personal representatives of the 2003 will to Mr. Ramzan in 2011. The litigation was started in 2012 and then concluded in early 2014. So prior to late 2010 and after 2014, this point has no relevance, because prior to then and after then, Mr. Ramzan could not have been purporting to occupy on the basis of anything other than the 1997 will.
Sorry, could you say that again? I've got the your dates for the grant of probate,
Yes.
registration, litigation, and resolution of litigation.
Yes.
So 2010, 2011, 2012, 2014.
Yes.
And then you went on, Mr. Shovels, to say?
Yes. What I'm saying is, Mr. Ali said candidly, the late Mr. Ali said candidly in his witness statement that he wasn't aware of the 2003 will until he started that action. It follows that in no sense could, prior to the grant, at least prior to the grant of probate, so that's 2006 to 2010, could Mr. Ramzan be purporting to, be said to be purporting to exercise any right other than under the 1997 will, or at least it was ambiguous as to why he was there.
Was he exercising a right under any will?
Indeed.
At that point, he might have been a licensee from his mother.
Yes. Well, the licence itself would have automatically terminated on death.
On her
it would
death?
have been
When did
but
she
on
die,
her
remind
estate.
me?
2006.
Oh, right, okay, sorry.
But from her estate.
Right, yes, a licence from her estate.
And then from 2014, early 2014, once the 2003 will is declared invalid, he cannot possibly, from then on, be purporting to occupy under that anything other than the 1997 will. So, even if this argument is a good one, it really only covers the period late 2010 to early 2014. The principle, however, is this, that in fact the property was only ever held, as the 2014 case judgment determined, on the basis of the 1997 will. And the incidence of legal title has nothing to do either with the occupation, if he had rights under either of those, or its effect, we would say, upon the appellant. It is not as if he would have occupied, we say, under the 1997 will, even if there hadn't been an issue as to whether there were a later will that was valid. It's also said that that is relevant because of the dispute and the first respondent's failure to sell. It is said that Mr. Ali was unable to do anything, unlike the trustee in bankruptcy in French and Bartram. That, with respect, I think puts the case rather too highly. Rather, he could not have perhaps directly asked for an order for sale, although, I'll come back to that in 1 second, but he certainly at very least could have sought an order for the administration of the estate, which would have included an order that the trustees sell the property. And the distinction between those is one, in my respect, without a difference. It was always in his hands to do something about it. The point I said I'd come back to is this. I said that it was open, he could not have himself applied for an order for sale. If, however, once the residuary estate has become ascertained, of course he could, because now he doesn't have an interest merely in the administration of the estate, due administration of the estate. he has a direct interest in possession in the asset, and therefore he has locus to apply for an order of sale under section 14. For what it is worth, however, the learned judge, who was the judge in the 2014 action as well, and indeed the 2016 substitution of the personal representative, the first respondent for the personal representatives that they were at the time, knew very well the history of the matter, and would have known, and therefore one cannot say that he failed to bear in mind that particular point. The final point on which specific point on which Milner and Friend relies on under ground 3 is that the parties' relationship was always difficult. In fact, that is not how the learned judge found. He found that at least until 2012, the parties' relationship was a good one. There was a disagreement on the evidence, and on that regard, he preferred the evidence of, in that respect, he preferred the evidence of the second to fourth respondents over that of Mr. Ali. The principle, however, that's the fact. The principle in relation to ouster is a more general one. In all cases where the court has asked to consider whether or not to order an occupation rent and has formulated the appropriate test, have been ones, as I think the learned friend alluded to earlier, ones of both co-ownership and cohabitation. They have been family homes for the purpose of the occupation of husband and wife, partners. And that no longer applying the old Section 30 law, the purpose of the trust had ceased to exist at the point when the parties' relationship ended. Therefore, one can see that at that point, the occupying beneficiary there is more justification for an occupying beneficiary paying an occupation rent, because they can no longer say, I am occupying in accordance with the intentions of the settlors as they were. This, however, is a different case. This, I think, is unique in all of the cases that we have cited, in that it is a co-ownership but not a cohabitation case. And therefore, and by virtue of the nature of the property, it was only ever appropriate that one family should occupy it at any one point in time. In those circumstances, the notion of a constructive ouster or unreasonable to occupy are very different from those in the case of the cohabitation cases. The obvious trigger, it wouldn't be right for husband to be there while wife is, or vice versa, one partner to be there while the other is. An argument which holds good in the cohabitation case, it no longer does not hold good in this case. And therefore one struggles to find an appropriate factor which would justify the making of an award in these circumstances. The nearest one gets, although it is not a very near miss, is the case of Armin and Armin, which I cited, which involved, I think, Kingsley Manor, which was occupied by two brothers and mother. The two brothers fell out, one left. The court accepted it was unreasonable for him to return by virtue of the nature of the relationship between him and the occupying brother. But the court found that the mother was still in occupation, and the court found that that purpose, which was always part of the purpose of the trust, subsisted, and by virtue of that, albeit some other factors I must accept, therefore it was inappropriate to award an occupation rent. The other reason the court said is, well, how can I quantify what that is given mother's there? How do I take into account which bits she occupies, which bits the occupant occupies, and the care and service that he provides to her, none of which applies here, of course. But nevertheless, it expresses the general point that where, despite a family breakdown, where the purpose of the original trust subsists, that is a factor against the award of an occupation rent. So there was
a case I tried last year called Gandesha, and Gandesha, which was another family occupation of a large house, but that was under Talata. And so because it was under Talata, it was slightly different, but exactly the same sorts of issues arose.
Yeah. No, I'm sorry, I wasn't not aware of the case. Finally, on this point, Millennium Friends, and I'm perhaps coming back to a point I raised earlier and should have addressed then, the Kingsley argument, that because the circumstances here are analogous to Kingsley, and I think the argument is this, that whilst even accepting that whilst Mr. Ramzan might have occupied as a beneficiary under the 1997 will, because he occupied under the 2003 will, therefore he's liable to an occupation rent. The problem with that is it doesn't sit with Kingsley. In Kingsley, there were the point is that I never had a right to occupy under the 2003 will. In Kingsley, there were two bases on which the sister could have occupied the property. The first was as beneficiary, which would have potentially rendered her liable for an occupation rent. The second, as the partner in the business who had an implied license in order to wind up the business, for which she wouldn't be liable for an occupation rent. The court there just simply asked itself, as a question of fact, what was the nature of her occupation? Was it as a beneficiary or was it as partner? And it determined it was the former, and therefore it was open to the claimant to claim an occupation. It wasn't because she had purported to exercise in some other capacity. In fact, the court decided that she hadn't, that she was liable to an occupation rent. So Kingsley could only apply here if Mr. Ramzan was occupying otherwise than as under the 1997 will, and by virtue of that occupation, he was susceptible to an occupation rent. To which the answers are twofold. First, while I may have he may have mistakenly occupied under that basis, but he had no right. And secondly, even if he had that right, it would not have rendered him liable to an occupation rent. So this is entirely the opposite of Kingsley, where the basis on which she in fact occupied, and admitted she occupied, made her potentially liable to an occupation rent. If Kingsley applied here, and by virtue of Kingsley an occupation rent was justified, I hesitate to carry on because I know that I'm falling into the trap of an argument, an absurd argument. One would reach the conclusion that if A had two potential bases of occupation of property, one justified, one not, if he purported to act on the unjustified basis, he would be liable to the other owners, even though he had a perfect right to occupy on that first basis. And so one would look at the subjective intentions of a particular individual, and if they were mistaken, he would be liable. That cannot be right in my respective submission. It is, moreover, a point which has some application to Creasy and So, although it was never argued there, because in that instance, Michael first argued that he was entitled to occupation by virtue of an agricultural tenancy, or by virtue of an estoppel. And the learned judge found against him on both of those. But it was not then said that because he purported to act on that incorrect basis, therefore he could not claim to have acted as a occupied as a beneficiary, or that by virtue of that he would be liable to an occupation rent. So the argument which is being deployed here is one which would have had an indeterminative impact on Creasy.
The inquiry in Creasy would have stopped there if that was an answer, if that were the only argument, because the judge wouldn't have needed to go on to look and see whether or not he had an interest in land.
Yes.
Yes.
Yeah. unless I can assist the court further, those are my points on ground 3. On ground 4, there is a two-stage argument here, much of which I think I've already addressed. The first stage of the argument is that trustees in bankruptcy are ordinarily, if not invariably, entitled to an occupation rent, French versus Davis, and then there are no extenuating circumstances against making an occupation rent. The first point to make is that the cases give the results of the cases give the lie to the first proposition, and there are 3 of them. Firstly, there is Armin, where notwithstanding there was a constructive ouster, no occupation rent was ordered because Mum was still there. Then there is Davis, where whilst the trustee in bankruptcy clearly could not reasonably be expected to occupy in conjunction with the wife because the husband never could, an occupation rent was not ordered. And thirdly, in Stack and Dowden, although in the House of Lords there is very little analysis of this, at first instance I think an occupation rent was ordered to be paid by the occupying beneficiary. That was reversed by the Court of Appeal, although it was clear as a matter of fact that she had refused to permit the husband to reoccupy. And in fact, I think Lord Newberger says that at 157, and Byford also alludes to it. Notwithstanding that, the majority, that is Baroness Hale and the rest of the court, upheld the Court of Appeal's decision not to award an occupation rent. She doesn't say why, she just says that she agrees with the Court of Appeal. Lord Newberger said he would have reinstated the Court of Appeal, would have reinstated the first instance determination. Because there had been, for various reasons, but 1, there had been an exclusion. 2, in an earlier stage of the proceedings, the occupying beneficiary had agreed to pay for the non-occupying beneficiary's rent, to rent alternative accommodation. So notwithstanding, there are 3 examples of instances where, notwithstanding the first stage analysis is met, would it be unreasonable to occupy. The court at the second stage determined that it would not be reasonable to require rent to be paid. In the case of a non-occupying beneficiary who has no occupation rights, it's difficult to know what the court would in those circumstances be compensating him for or her for. The argument has been put that but the trustee in bankruptcy cases are such cases. In my research, they are not, because in all of them, it properly analysed. The court is saying, in theory, the trustee in bankruptcy at least potentially has such occupation rights, but either by virtue of Section 12 or simply he does not, or by virtue of the other beneficiary occupation, it will be unreasonable for him in those circumstances to do so. In my research, those are not cases which can apply if the learned friend is right, that nobody had a right of occupation, or if I am right, that whilst I might have had a right of occupation, the appellant did not. I can quickly give my lord and my ladies the references. Byford, at 17, the trustee in bankruptcy argued he wasn't free to use the property while the co-owner was resident, and at 40 the court agreed. In French at 18 and 19, it seems to assume that a trustee in bankruptcy has no occupation rights, albeit arguendo. And then at 34 and 35, the court seems to say that he does have such rights, or he would have had such rights, but for the other occupying beneficiary's presence. And similarly, Davis at 47 assumes that, but for that presence, he would have such rights.
That's Davis at 47?
Davis at 47, yes. And then at 61, it is some conduct of the beneficiary or some other feature relating to him, which makes it unreasonable for those rights to be.
Paragraph 61 is the heart of the case. I take it.
Yes.
That's the key passage.
Yes. Conversely, the one example where of a beneficiary without occupation rights, where that is not solely by virtue of the other beneficiary's occupation, the only case which I know of that considers that instance is Davis. Yeah. And in Davis, of course, that is the reason for not awarding an occupation rent. Yeah. So here, if aside from my presence, Dr. Ali or Mr. Ali would not have those rights. So the second point I make in relation to trustee and bankruptcy cases is this, that they are merely instances, specific applications of the general test, which is it reasonable to expect you to occupy? And obviously, in trustee and bankruptcy cases, that is a very different question to where it is a pure co-owner case. Then moving on to the question, so in my respect submission, no relevant misdirection is shown at the first stage of the analysis by the learned trial judge. Well, then comes the second stage of the analysis, and the question, the questions to which my learned friend alluded earlier. One being the question of the overpayment, and there are, as was indicated earlier, two aspects to this. The first is, did they increase the value of that share? Secondly, there is the overpayment, even on the basis that of its current value. It was accepted that those values were admissible, and Mr. Kember, my learned opponent below, merely argued that it was a matter of weight to which the court would attach to them. But under those, the last valuations were of £225,000, and then an alternative valuation of 250 or 220 without the improvements. And the last of those was, I think, in April 2019. The agreement in early 2020, so about 7 months later, valued the property at £320,000. So, on the latest valuations, and ignoring for the moment the value of the improvements as found, there had been an overpayment, even on its current value, of about £25,000 for the quarter share. 1/4 of £100,000 being the overpayment. 220 or 225 versus 320. The other evidence before the court was that since the property had probably doubled in value since 2010, when it might otherwise have been sold. There is no ground of appeal concerning the treatment of that. And therefore, the arguments that my learned friend raised earlier are not, in my respectful submission, arguments open to.
When you say of that, you mean the treatment of
the £80,000,
of the 80,000,
and whether or not that was a factor which the court could take it into account, and whether it took it into account in the appropriate way. That is not a ground of appeal, nor is it in my learned friend's skeleton. But if, but moreover, if, as the authorities show, this is simply an exercise of a broad judgmental discretion, it is difficult to see why it is not a relevant fact. In Davis treated it as a relevant fact. Well, one of them treated the delay and the increase in value by virtue of the delay as a relevant factor.
Well, what's said against you is that that was because there was an inability to realise it earlier.
Yeah, in this case there was an inability to do so, in that case not, and that there was some element of fault there.
Yeah.
That, in my respects, really is a clever argument, but it puts a gloss on Davis which just isn't there. It would, in my respect, summation, impermissibly fetter what is a broad judgmental discretion to say that you may only take that into account if you attribute that to some lack of fault on the part of the applicant. But more than that, as I argued earlier, it was always just as the trustee in bankruptcy had it in his hands to do something about it, it was always in Mr. Ali's hands to do something about it. As I said, either apply for an order for administration of the estate or apply for an order for sale because the residue had been ascertained. So in my respect, submission, the Davis is on all fours with the present. The learned judge had in mind the figures for the rent, and though he does not go set out the headline figure, it is worth pointing out that the figure as claimed was approximately £155,000 in total. That was on the mistaken basis that the second respondent would be liable to pay the entirety of the market rent due. It was conceded quite rightly by my learned opponent below that in fact that wasn't the case, that in fact he was only entitled to a quarter share of that. A quarter share of that, leaving aside my claim for credits, would have been a little under £40,000. The learned judge certainly had that in mind at the point where he decided that the twofold benefits from capital, taking into account the claim for rent and ignoring for a moment my claim for credits against the rent, against an occupation rent, broadly equated to each other. So on a very simplistic analysis, one could say the property gone up by £40,000 over the last X number of years. You're claiming a little under £40,000 rent, and against that I can set off, again depending on how one quantifies it, about £10,000 worth of credits. About £40,000 in total was the amount I sought to set off. Now the learned judge made no decision on any of those, but he would have had in mind, will have had in mind, those figures in deciding whether or not it was a matter of broad justice, it would be appropriate to award that figure on top. My learned friend raised arguments in relation to the length of time during which I would be entitled to occupy the property. Is that something you wish me to address?
I don't think so, thank you.
I'm grateful. Unless I can assist the court further, now ground 5, I have, forgive me, I've always regarded as something of a sweep up, and I think I've probably addressed
Well, that's the way it's sort of pleaded. It sort of morphed into a discretion argument.
Yes, and as was mentioned earlier, it's not for my learned, not criticising him, but it's not for my learned friend to re-argue the case, which there has been a tendency, I have to say, to do this. But he must satisfy the court that in some respects the exercise of the discretion went wrong in one of the ways which my lady described earlier. In my submission, no proper error, admissible error is shown. So unless I can assist the court, those are my solutions.
Thank you very much. Mr. Darton?
Ladies, my lord, if I might just respond very briefly. Could I just say that in relation to Davis and Johnson, I think it's important to look at what it is actually authority for. As a consequence of the very pertinent questions that were put to me, I don't think we ever actually looked at what I said were the pertinent paragraphs, which I think, from 68 through until 70 and 71, which is the pages 435 and 436 of our authorities bundle.
Just hold on a second.
I'm so sorry, yes, my lord. And the reason I take you to those is because this is where I said, in relation to the learned trial judge's assessment of how he treated Davis and Jackson, that he read from, he cited paragraph 69, but he didn't refer to paragraph 68, which preceded it, which I submit encapsulates the argument I made this morning about this distinction between the right of the trustee to seek a sale and, as of course your ladyship, my lord, will have seen, it refers also to the case of Byford. So if there is an outlier, I would respectfully submit that there are two outliers. I don't know whether that is impossible, but there are definitely two. And that is certainly the opinion of Mr. Justice Snowden, as he then was, because if one has a look at paragraph 70, he doesn't say they're wrong. He says he declines to reach a firm conclusion on either of them. He bases his decision on what follows at paragraph 71 onwards, which are the peculiar facts of the case as I have described this morning, namely that the bankrupt husband had never intended to occupy the property and had never occupied the property. And as I indicated to the court earlier this morning, under Talata, of course, the purpose of the trust is relevant. And I shall come back to that in a moment in the case of Armin and Armin. So I would submit this court can't peg anything on the decision in Davis and Jackson because it is plainly limited to his facts, and that was as far as Mr. Justice Snowden went.
Well, of course, we're not bound by either of them.
Well, of course you're not, my lady. But those two cases are not outliers, and I'll come to Armin. So I'm submitting that actually what you have, in truth, are observations by Mr. Justice Snowden, as he then was, saying, I don't necessarily agree with those, but you don't have a decision. The decision sits with French and Barham, which built upon Reed Byford's case. So actually, I would submit that the body of jurisprudence, and I accept, as my Lady Lord Justice Andrews has said, yes, they're not binding on you, but actually, the preponderance of the authorities is my way, not my learned friend.
What, two rather than one?
Well, that's still a majority, I think, on a...
Well, you're missing out everything from Jones and Jones upwards.
Well,
point I was making to your opponent was that Davis is in line with Pavlou and all of the cases that go before that. Byford I hadn't really focused on, but you're right, Mr. Justice Snowden didn't need to grasp the nettle and say that he disagreed with the outcome in French because he had factual basis for distinguishing it.
I'm grateful. Could I then, if I might, moving as swiftly as I can, just take you to the case of Armin that my learned friend cited also, because, and if you'll forgive me, that will be at tab 14, I hope, because this was a decision of Mr. Justice Warren, and what I would like to take you to is page 244 of the electronic bundle, if I may, where I would submit a paragraph 291, he adopts the decision in French and Barcham. So nobody else is seeing an inconsistency in my submission. And if we then go on to page 246 of the electronic bundle and look at paragraph 302, we see why no occupation rent was payable, and actually it coalesces exactly with the circumstances in the Davis and Jackson case, because one is looking at the purpose of the trust, which is consistent with the terms of Talata. In other words, this house was always intended as a home for mum and dad. As long as mum is still alive, the purpose of the trust is being fulfilled. Ergo, that rebuts any payment of an occupation rent. So I'm submitting that yes, none of these first instance decisions are of course binding on this court, but actually all of them go my way. And that actually in Davis and Jackson, the reason why Mr. Justice Snowden was tempted but declined to make a contrary judgment was because of the fact that the trustee in bankruptcy has this right to force sale. That's what I read out of paragraph 60. That it's the fact that in that situation, the trustee can take the circumstance into his or her own hands.
Sorry, so 90.
So this is 68, my ladies, my lord, page 435. Has the power therefore, where you have a period of delay in the non-pejorative sense, it must follow from the inaction of the trustee. And I submit that's all this is authority for. It is not authority to somehow say that what preceded was bad in law. And for the purposes of this appeal, what I contend is that it's clear from the judgment of the trial judge, he adopted the approach as interpreted by my learned friend in Davis and Jackson. So I say if Davis and Jackson falls, as it must, then the appeal should be allowed. Because there was a presumption, and there was good. Certainly, so far as the trial judge was concerned, there was binding first instance decisions on him. Can I quickly feel, and I note the time, with regard to the registration, I would submit that one thing is clear in this case, which is that if you're the registered freehold title, if you register yourself as a freehold title owner of the property, then you have the right of occupation. In fact, your registered title takes precedence ahead of everyone else. In the days when one used to do possession actions, what you turned up with was your registered title, because that proved that you were entitled to possession. So the point is that from the date of that registration, the second respondent was occupying on the basis as of right. So it did matter. That's why we say Kingsley's engaged. And that then takes me to the effect of the probate judgment, because, and I stand to be corrected on this, but my understanding of the revocation of the 1997 will is that you return back to where you were.
What do you mean by that? It's treated as if it's never existed.
Yes. Now, I accept, my lord, there may be arguments, if, for instance, where, for instance, you've carried out acts of administration, you would say, well, we don't have any findings on that. But it is revoked. And that really brings us back, and it's a word I hesitate to use long and hard, but jurisprudentially, whether the basis of an occupation rent rests on, as it were, the egregious actions of the occupier, in other words, the ouster situation, or whether it turns on the unfairness to the non-occupier. You have slightly different versions of that competing. What I say is that here, as a matter of law and as a matter of judgment, of the judgment, there was a sustained period of time when the appellant was entitled to a quarter share of the property, and thus putting it its lightest, faintest, a claim for an occupation rent and a right to seek a sale, which was not pursued through no fault of his. He is shut out.
What do you say about the point that's been made against you that he could have asked the executors to sell, administrators to sell?
Well, we could only do that once we'd established the correct will, my lady. We couldn't do it otherwise. So you can, if we haven't got any findings of fact as to the extent to which the second will ought to have been known to be bad for want of knowledge and approval, but it was revoked. And therefore, we go back to this point as to the injustice on our side, which is for a significant period of time, we could not have taken any steps. And
But from 2014 you could have done.
Well, yes, but again, it was asked of me, well, what period would you regard as a decent interval? And I think we actually do come up to 2016 before we seek a change in the administrator. Because the second respondent, I think, is administering. So again, we wait. So after the new will was established, we had to put in a professional administrator, the first respondent, and we succeeded in that, in essence, because the estate wasn't being properly administered, or that was a requirement in order to administer. So we did try to nudge it along. And can I deal with this point? Because it seems to me that this court, I would invite this court to grapple with it, because it's a difficult one in practice. If somehow the increase in value is to be a factor that's freestanding, it has the rather unattractive consequence that it will be this moving feast. There have been periods in the property market where the market has collapsed. So if you heard one day before the collapse, well, you've had a massive increase. If you hear one day after the collapse, well, actually, there hasn't been any increase. So it makes the whole process very, very uncertain, which is why I say the reason why you consider value in the context of Davis and Jackson is that the party that could force a sale has held their hand from doing so. It's that which gives it the operation. And whether it's relevant or not, the practical consequences of saying simply a rise in price is relevant could well be that you have occupiers holding out for the hope the value will go up, and so effectively they'll have been able to live there rent-free. It makes it a very, very uncertain process. Because it's not a case, as I say, where it has been an action on the behalf of the respondents that has resulted in the increase in value. It is simply the result of property prices. And you have my earlier point where we might have invested it in property and have enjoyed the same interest. And as I say, it all goes back to the deprivation of the interest. If I'm trustee and I don't choose to try and release my interest, then the fact that the property's risen in value may be a reason not to give me an occupation rent. But if I can't move, then I submit it's inequitable for me not to receive that. Now, Creasy, to receive the occupation rent.
Well, is this just a repetition of what you said?
Yes, my lord, which is why I slipped it in quickly and then moved on. But I do say that there is, from the points that have been made, when one goes back to, if you are persuaded that what I say was entirely obiter in Davis and Jackson is the right way to proceed, well, then you agree with the judge. I say that it is obiter, it isn't the right way to proceed, and that's why I make that response. And I say it has all these unattractive consequences. Could I just deal with just a couple more points? I note the time, although it seems to always be 8:30 in this courtroom. But
well, we are down the rabbit hole.
With regard to saying points that weren't argued, I would caution taking an overly pernickety way, because let's think about it for a moment. It was said, oh, we haven't argued these points. Oh, but you did say the failure to sell was argued. But if my predecessor argued the failure to sell, he's arguing within that all those issues.
I'm not following what you're saying, but I'm also concerned that this isn't necessarily a point in reply.
Then I shall move on, my lady. Finally, can I deal with paragraph 43 of the judgment? Because if it is a day for looking at things very precisely, I think in paragraph 43, the judge there is quite clearly looking at the rental value of the property when he says, it talks about his very broad brush approach, or a broad view of the various reports as to the rental value. He is not taking account of any repairs. He is not undertaking the calculations that my learned friend sought to argue might justify and support his conclusion. He is only...
It's just pure coincidence that the figure that he comes up with is broad brush what you come up with when you do the calculations, without taking into account of the repairs.
Well, my lady, I rely on what he says there, and he doesn't address those repairs, and if he were to do so, he would have to have made findings of fact in relation to them. And they are not straightforward, because of course there's an issue as to cost of repairs plus increase in value, and the extent to which they do increase the value and the circumstances in which they were undertaken.
Yes, but I think the point Mr. Sharples was making is leave aside the repair argument and the claim about the repair and just look at the rent. If you do the maths, it comes out more or less at the figure that the judge had in mind. The increase in value, or the surplus over, it equates to somewhere between 30 and 40,000.
Well, I can't do better than the judgment, and I don't think it's appropriate for this court to try and read into that judgment what, in terms of the wording, is not present.
Well, why, if at the end of the second line he's considering what might have been awarded by way of market rent, wouldn't what was to be awarded by way of market rent take into account repairs and such like? I don't understand. At the moment, I understood you to be saying 43 doesn't take account of repairs, and although they're not mentioned, surely the amount that would be awarded for market rent would take them into account.
Well, you could do it. I mean, I think if you put the repairs in, then you raise it up to 250. So you've got 225 without the repairs. Then we had a valuation of 250 in a repaired state, as I recall the evidence. So if you include the repairs, then you should take the 250. I'm hoping I'm getting this right. The sort of, as I recall it from at a much earlier stage in my practice. With repairs, there's two ways of looking at it: the increase in the value of the property, or the actual cost of the works done. And what you never got, you always got the lower of the two. So what I'm saying is, it's difficult to interpret in that way. He doesn't do it, he's not addressing it in terms of quantum. He doesn't address the arguments. There are very considerable arguments as to what should or shouldn't be included on the counter schedule. What he says is, I'm doing it on the values, the rental values of the property. And you have my arguments on that, which won't benefit from repetition. That is, my lord, unless I can assist you further.
No, thank you very much indeed, Mr. Darton. And thank you, despite all our intervention and time wasting, that you've both completed this today in good time. And thank you for your arguments. You'll be fully aware of the way that we operate in this court, in the sense that we are reserving our judgment now. You'll probably be relieved to hear. And a draft or drafts will be sent out in the usual way. That is an opportunity to correct typographical errors, not to re-argue the case in any way. And thereafter, we hope that you will be able to agree a consequential order. If you cannot, then please make your submissions succinctly in writing, and we will decide on paper. And eventually, the decision will be handed down electronically. I think you're aware of all of that. Thank you very much.
The last of the Rolls' recent judgment, the draft judgments, that's singing in the bar's ears with regard to their treatment. That is very clear on this side of the bar.
Thank you.
All rise.